All right, it is January 25th. The time now is 10:05, and I'd like to call the Woodland Hills Board of Appeals meeting to order. By way of introductions, I'm George Reed. This board, I don't know if you're aware, it's comprised of individuals throughout the industry that have been asked to serve on this board. It's a voluntary position. My day job is I'm the interim city manager for Vineyard City. I'm also the building official. And right here we have John Little.
I'm John Little. I'm the building official for Spanish Fork City.
John Snellborough, building official.
All right, so as far as business items go, we have the appeal submitted by tenant and Megan Fuja residing at 1105 South Woodland Hills Drive, in their claim that the City of Woodland Hills building official, illegal and arbitrary and capricious, issued an extension of temporary certificate of occupancy for the residents located at 115 South Woodland Hills Drive, Woodland Hills, Utah. I guess should we let the applicant say their claim, and then we'll let Corbett speak on the behalf of the city, and then we'll go from there. So if the appellant would please come forward and fill us in on all the details here.
Before I begin, I just want to make sure that those who are listening via Zoom can hear. So if you could provide confirmation that you can hear so that we have an accurate record, that would be much appreciated. Before I begin and put on my time, there are a few housekeeping things that I want to understand as we begin this process. First of all, as the petitioners, I understand that we've been given 20 minutes to present our information, and then the city will be given 20 minutes to present their information, and then be given 10 minutes of closing arguments, and then we'll be given the opportunity as petitioners to provide the last 10 minutes of closing statements. Am I understanding that correctly?
That was the recommendation of the city, and we will follow that recommendation. Thank you for clarifying that. Yes.
Perfect. And then also, just for housekeeping purpose, obviously under IRC-IBC rules, we have to ensure that we have individuals who are sitting who are qualified to hear the matters before the board. And so, because I don't know any of you, I just want for the record, are you certified, are you engineers licensed in the state of Utah, any of you?
No, I'll answer for myself and let these gentlemen speak for themselves. So I am a certified licensed combination inspector. I'm the building official for Vineyard City. I've been in the inspection industry now for 15 years. And I currently also teach part-time at Salt Lake Community College.
Very good. Thank you for your time, first of all. Yeah.
So no, I'm not a structural or licensed engineer. I am licensed through International Code Council. I also am a combination residential and commercial inspector. I've been in the inspection industry since 2005. And I am the current sitting building official for Spanish Fork City and have been for 6 years or so.
Very good. Well, thank you for being.
So John Snellborough, state licensed combination building inspector, master code professional with the ICC, over 20 years in the inspection business, a general contractor before that.
Okay, very good. So then just for the record, I'd just like to note that we're going to be presenting and have presented to the city information that's technical related to both civil, structural, and geotechnical engineering. And so we need to make sure that those individuals who are going to be passing adjudication on these matters have the sufficient technical skill. And so that's just a first item of indication and protest that we'll raise at this point in time.
And Yeah, excuse me, let me just clarify.
Uh-huh.
So this appeal is an appeal of the building code. And as such, the two gentlemen and myself are very well qualified to handle any appeal of the building code. We are not here to talk about any engineering principles, practices, or anything like that.
Right.
Just what is allowed and not allowed within the building code.
Right. And as the building code clearly states, we need to ensure that we have individuals that are qualified. So if you feel yourselves qualified, then that will be fine. We have to recognize, though, that here today we have both civil, geotechnical, and structural engineers who will be presenting, as well as one individual who have proffered testimony. So we just need to make sure that that's on the record for district court. The other point is we have 3 individuals who will be giving testimony, and I would like to not have their time in getting to and from the microphone counted as my time if I could. Okay. Again, now before we get started, thank you for being here. I can't tell you how excited I am that we can finally have this hearing. We've been waiting for months and months to have a hearing on these important matters, and we're glad to be here. All right, gentlemen, for the record, let me just please read the full statement of the appeal. The building official's illegal, arbitrary, and capricious issuance or extension of a temporary certificate of occupancy when the building official has a mandatory duty to revoke or suspend that certificate because of known determined building code violations, incorrect information supplied in construction documents, and known violations of ordinances and regulations of the jurisdiction. That's the full appeal. I'd first like to proffer the testimony of Mr. Matthew Robles. And again, I'll pause here my time so I can present this to you. Gentlemen, hopefully you've been given this information as was provided to the city, but now you've been duly served, and that becomes part of the record of this official proceeding in this matter. And I'd like to now proffer part of the testimony that appears there for Mr. Matthew Robles. I am a board-certified licensed structural engineer in the state of Utah. I am current American Society Civil Engineers Region 8 Governor. I am owner of McNeil Engineering in Sandy, Utah. I was ASCE Utah Section Engineer of the Year in 2007. I have not been paid to render a specific opinion on this matter. I am familiar with the subject matter and the technical data at issue in this matter. The few just have... All right, well, I still am under some time constraints. I'll do my best. The few just have not dictated or influenced my professional opinion in any way. As of November 30th, 2021, the structure, which is the date of the issuance of the temporary certificate of occupancy, was not substantially in compliance with the IRC-IBC codes and the other various ordinances of the city regulating building construction, and substantial hazards did and currently do exist at the site. The city has willfully and intentionally refused to enforce mandatory provisions of the Utah State Building Code and the mandatory land use regulations of the city. The building official, building inspector, zoning enforcement officer, mayor, and city council have intentionally and maliciously refused to perform their legal duty to enforce various ordinances and mandatory land use regulations regulating building construction, knowing that their action, as required by law, has endangered the general public and endangered, injured, and damaged the Fuges and their property, as I have affirmed in numerous stamped and signed reports, letters, and declarations. Per 2015 IRC 110.5, in my professional opinion, the building official has a mandatory duty to revoke or suspend the temporary certificate of occupancy immediately, and given all of the information provided to the building official / building inspector, failing to make this legally required action amounts to official and willful misconduct. The city has willfully and intentionally acted to conceal important data and evidence. The actions of the city to refuse to require independent verification of the as-built structure and accurate plans reflecting the as-built structure has knowingly concealed evidence and impaired the availability of important evidence in this matter to prevent the production of documentation and data which reasonably would be anticipated to be evidence in these official proceedings. In my official work, I frequently interact with municipal governments. I have never experienced the level of illegal and intentional misconduct I have witnessed from the city of Woodland Hills. Their actions completely undermine the building permit process and intentionally endanger the life, safety, of the general public. Their illegal actions in this matter are some of the worst I've ever seen in my professional career. Stop. I'd like to call now Mr. Conrad Guyman. You'll have to speak right into that.
Okay.
What is your name?
Conrad Guyman.
Please summarize your professional qualifications and experience.
I'm a principal at CKR Engineers, which is a structural engineering firm in Orem. I've been practicing structural engineering since 1996, which is about 25 years. Projects have consistently included residential design, repair, and reconstruction over that entire time period. I have a Bachelor of Science degree from Brigham Young University, a Master's of Engineering Management from Brigham Young University. I hold structural engineering licenses in Utah, California, Nevada, Hawaii, and Georgia, and I have professional engineering licenses in 10 other states.
Are you comfortable removing your mask?
Yeah.
If you can, it might be a little easier to hear.
I'm currently the chair of the Structural Engineering Institute for the American Society of Civil Engineers Utah section. I'm a board member of the American Society of Civil Engineers Utah section. I hold NCEES Model Law Engineer designations and Model Structural Engineer designations. Those are related to education and examination requirements for licensure.
Are you familiar with the subject matter and technical data at issue in this matter?
Yes, I am familiar with this.
Have the fuges dictated or influenced your professional opinion in any way?
The fuges have not dictated my professional opinions. My professional opinions are my own.
Is it your professional opinion that the residence or some portion of the residence is in violation of any ordinance or provision of the IRC-IBC?
Yes, there are portions of that residence that are in violation of the IRC and IBC.
Please explain.
The north foundation wall does not meet the requirements of IRC section R404.1.1 with regards to unbalanced backfill requirements. It exceeds the height requirement in the state of Utah Amendment Table 1806.1.6.4 regarding empirical foundations. It does not meet the horizontal reinforcement requirements of ACI 318, section 11.6. and does not meet the strength requirements of ACI 318, section 11.4. The soil below the interior bearing wall footings has not been demonstrated to meet the requirements of IRC section R401.2 regarding compaction and bearing capacity. The grading shown on the unapproved site plan does not meet the requirements of IRC section R401.3.
Again, in your professional, and you've documented all of this to the city in your reports.
Yes, we have submitted multiple reports.
Again, in your professional opinion and after careful technical evaluation, does the construction at 1115 South Woodland Hills Drive, we'll refer to that herein as the site, comply with IRC codes and the Utah State Amended Building Codes?
It does not fully comply with the codes.
Has the work installed at the site been in accordance with approved construction documents?
It has not. There have been known departures from the approved construction documents for the house.
Is it your professional opinion that the city, in your professional opinion, does the city have accurate plans that reflect the departures of the as-built structure?
The city does not, to the best of my knowledge. There have been departures that are as yet undocumented.
Additionally, does the city have an accurate site plan?
The site plan is still awaiting approval, so no, they do not have an accurate site plan.
So again, to be clear, we don't have accurate construction documents for the building or the site plan.
Correct. The construction documents do not reflect what has been built, and the site plan approval is still outstanding.
Is having accurate construction documents, i.e. building plans and site plans, a requirement of the IRC-IBC code 2015 IRC R106.4?
Yes, accurate construction documents are needed to demonstrate code compliance.
Is having accurate, okay, you've answered that question. In your professional opinion, is independent verification of the as-built structure necessary to determine the accuracy of the construction documents?
I've recommended independent verification of the structure on several occasions in the documents that have been submitted.
Has the city performed this work?
To my knowledge, no, that has not been performed.
Is it your professional opinion that the certificate of occupancy issued by the city building official was issued based upon incomplete and incorrect information?
Given that accurate construction documents do not exist and the bearing capacity of the fill has not been documented, I would say that the certificate was issued based on incomplete information.
So again, just to review here, we're dealing with a situation where we've departed from the building plans and we actually don't know entirely what has been built because it hasn't been documented by the city. Is that correct?
Yes, that's correct.
You have provided this information, I think you've already stated, in detailed reports. In your professional opinion, should the structure be occupied?
Given the instability of the north foundation wall that has not been demonstrated and the capacity of the bearing soils below the interior footings, I don't think it should be occupied at this time.
Per 2015 R110.5, in your professional opinion, does the building official have a mandatory duty to revoke or suspend the temporary certificate of occupancy?
Given the wording of that section, yes, he does.
As you sit here today, do you stand by your written professional opinions and statements that you've made to the city in this matter?
Yes, I do.
Have the actions of the city to refuse to require independent verification of the as-built structure and accurate plans reflecting the as-built structure concealed evidence or impaired the availability of evidence and prevented the production of documentation and data which reasonably would be anticipated to be evidence in these official proceedings?
Without the accurate documentation of what has been built and what is proposed, they have impaired the engineer of record's ability to demonstrate compliance with the building code. They have also impaired the ability of the reviewing engineer and other officials to determine compliance with the code.
Great. Thank you, Conrad. Bill? Could you state your name?
My name is Bill Turner.
Please summarize your professional qualifications and experience.
I have a Master's of Science and Bachelor's of Science from Brigham Young University. The Master's was obtained in 1986. And I've been practicing geotechnical engineering for the last 35 years.
Have you been paid to render a specific opinion in this matter?
No, any opinions I have given, and I've given several in documents to the city, are my own.
So are you familiar with the subject matter and technical data at issue in this matter?
I am.
Have the Fuges dictated or influenced your professional opinion in any way?
No, like I said, my opinions are my own.
Is it your professional opinion that the residence or some portion of the residence is in violation of any ordinance or provision of the IRC-IBC?
Yes.
Please explain.
Okay, the section 401.2 says that fill soils that supports footings and foundations shall be designed, installed, and tested in accordance with accepted engineering practice. We have documentation that fill soils were placed beneath the north footing wall and that those have not been tested.
Again, in your professional opinion, after careful technical evaluation, does the construction of 1115 South Woodland Hills Drive comply with the IRC-IBC codes and the Utah State Amended Building Codes?
No.
Has the work installed at the site been in accordance with approved construction documents?
No, it has not.
Are there departures from the approved plans?
Yes, there are.
In your professional opinion, does the city have accurate plans that reflect the departures of the as-built structure?
As Conrad said, no, they do not have the accurate plans.
Is having accurate construction documents for the site plan a requirement of the IRC-IBC codes 2015 IRC R106.4?
As I read it, yes, they are.
In your professional opinion, is independent verification of compaction and backfill necessary to determine the accuracy of the construction documents?
Yes, that's very crucial for this.
As of November 30th, 2021, was the construction substantially in compliance with IRC-IBC codes and the other various ordinances of the city regulating building construction, and no substantial hazard existed?
No, that's not.
Is it your professional opinion that the certificate of occupancy issued by the city building official was issued in error?
Yes, I believe it was.
You also provided a detailed stamped signed reports to the city containing all of this information. Is that correct?
Correct.
Okay. In your professional opinion, should the structure be occupied?
No, I do not believe it should be.
Per 2015 IRC R110.5, in your professional opinion, does the building official have a mandatory duty to revoke or suspend the temporary certificate of occupancy?
I believe he does, yes.
Do you frequently work with municipal governments?
I often do, yes.
Have you ever experienced this level of difficulty in working with any other municipality in the state of Utah?
No, in my experience, if there's any issues, they immediately try to rectify those issues.
As you sit here today, do you stand by your written testimony and professional opinions and statements made?
I do.
Okay, thank you, Bill. State your name, please.
My name is Kyle Spencer with Northern Engineering.
Please summarize your professional qualifications and experience.
I am a graduate from Brigham Young University in the College of Civil Engineering. I'm licensed to practice in the state of Utah. Been licensed for practice for 25 years plus. Working mainly general civil, site plans, engineering, subdivisions, and also similar to this, residential site grading and drainage plans.
Have you been paid to render a specific opinion in this matter?
No, I've not.
Are you familiar with the subject matter and technical data at issue in this matter?
Yes.
Have the fuges dictated or influenced your professional opinion in any way?
Nope. What we found in the plans, I mean, facts are facts when we look at a plan to review them.
Is it your professional opinion that the residence or some portion of the residence is in violation of any ordinance or provision of the IRC-IBC?
Yes, I believe there are. I think that started even on the initial original site plan that was prepared on this site with the errors on mainly on the grading and drainage component of the site plan, which then dominoes back into the structure as we know.
Are there specific IRC-IBC code violations that you'd like to discuss?
Yeah, there were a couple. On the IRC 2015 section R401.3, when it talks about the drainage, as we all know, the grading shall fall a minimum of 6 inches within the first 10 feet. That's going to adequately get the water away from the structure. And I know there are some exceptions where we have concrete and other items. The other IRC code I just want to reference is R404.1.6, which is the height above the finished grade, and it reads, concrete masonry foundation walls shall exceed above the finished grade adjacent to the foundation at all points a minimum of 4 inches where masonry veneer is issued, and in this case, a minimum of 6 inches elsewhere. And that's pretty common, and that's one thing that as far as verifying that we can have a positive grade away from the structure and meet that 6-inch foundation exposure is going to be extremely difficult.
Difficult with the current plans and state of construction?
What we've seen on the plans, yes, near impossible.
Okay. Again, in your professional opinion and after a careful technical evaluation, does the construction of 1115 South Woodland Hills Drive comply with IRC-IBC codes and the Utah State Amended Building Codes?
No.
Has the work installed at the site plan been in accordance with approved construction documents?
I'm not aware of any approved construction documents to date, so no.
That are accurate presently?
That are accurate and complete.
Are there departures from the originally approved plans?
Definitely. Yes.
In your professional opinion, does the city have accurate plans that reflect the departures of the as-built structure?
Best of my knowledge, no. We're still waiting to see the final site plan.
In addition to the site plan, do they have accurate plans for the building?
Not to the best of my knowledge.
Is having accurate construction documents, building plans, and site plans a requirement of IRC-IBC codes 2015 IRC R106.4?
My understanding, yes.
Is having accurate building and site plans necessary in determining code compliance?
Yes.
In your professional opinion, is independent verification of the as-built structure necessary to determine the accuracy of construction documents?
Oftentimes, no, but in this case where we have some critical grade issues, especially in the front of the yard, that not only impact this home, but the adjacent properties, most definitely, yes.
And in addition to grading, is it important to know the accuracy of the structure as built as well?
I believe so.
Is it your professional opinion that the certificate of occupancy issued by the city building official was based upon incomplete or incorrect information?
Yes.
As of November 30th, 2021, was the structure substantially in compliance with IRC-IBC codes and other various ordinances of the city regulating building construction and no substantial hazard existed?
No.
You've provided this information in stamped and signed written professional reports to the city, is that correct?
Yes.
In your professional opinion, did the city have a duty to stop work once they received those reports?
Typically, that's the case until we come up with a reasonable solution on the site design or structure.
Did the city take those actions in this matter?
No.
In your professional opinion, should the structure be occupied?
No, not until these items are resolved, not only structurally, but on the site plan.
Per 2015 IRC 110.5, in your professional opinion, does the building official have a mandatory duty to revoke or suspend the temporary certificate of occupancy?
Yes.
As you sit here today, do you stand by your written professional opinions and statements made?
They are my opinions, and yes, I'll stand behind them.
Great, thank you.
Thanks.
Gentlemen, it appears that I've saved 2 minutes off of my time, so if I could be given that back on my 10 minutes at the end for a 12-minute total, would that be all right? Great, thank you.
So does that conclude your first? Okay. Corbett, would you like to tell us your side?
I guess first, for a little clarity, in Mr. Fuge's opening statements, he claimed the last 10 minutes of the meeting. And I don't think that's the way the process works. He gets 20 minutes, I get 20 minutes. He gets 10 minutes for rebuttals, I get the last 10 minutes, just for clarity. Is that correct?
I don't know how my counterparts feel, but I think what we'll do is we'll have your testimony given, and then I would say discussion, and then we'll go from there.
Okay, all right. First and foremost, I would submit that the engineers that the Fuges have presented have never made a site visit. Everything they've done is simply by the word of the Fuges. If they have gone on the property, they've been trespassing. And so I would hope that they wouldn't claim that they've been on the property and that everything they've done has been from off-site. So to have personal knowledge on how things have been done, how things actually got done, I think is ludicrous. He's claimed that there's a requirement for compaction underneath the basement slab, and that slab is non-bearing. I don't understand why there would be a requirement for compaction. They claim that that there was fill material underneath the foundation wall on the north end of the home. That's also false. Now, all these inspections were done and passed. The reason they dropped that north foundation wall to be a 13-foot wall was to get to native material, or to get to good material that was below the organics. It's not on fill material. It's on native material. And so, I mean, that's an untruth. I did the inspections on the home through underground plumbing. Sunrise did the inspections after that. Every inspection passed. Again, they've never been on site. All they've been able to do is look at plans. I would submit that in the IRC and the IBC, the Constitution of a Board of Appeals gives the right to appeal a decision of the building official. In the commentary to both codes, it states that the appeal board is created for an aggrieved party with material interest to be able to appeal the decision of the building official. I would submit that the Fuges are not aggrieved parties, even though they claim they are, and that they have absolutely no material interest in the decisions of the building official. They've claimed flooding, the risk of flooding, yet the engineer of record has determined that post-construction flows, he has mitigated 100% of post-construction flows. Pre-construction flows or historic flows, he's mitigated almost 94% of the pre-construction flows. Therefore, there is no risk of flooding to the Fuges. And so I fail to see how they can claim that they're an aggrieved party in this at all. And so to me, this meeting is worthless because they have no right to appeal the decision of the building official unless they can prove that they're an aggrieved party. And so, again, their engineers have never made a site visit. They claim that the plans have deviated from the original documentation. And yes, they have. They dropped the foundation wall to be a frame. They removed a portion of the above grade concrete foundation wall to be a framed wall. They added windows on the front of the house on the basement in that new framed wall that was originally designed as a concrete wall, and they lowered the foundation to get into better soils for the footings to bear on. And so I fail to see how the fuses can prove any of this. Again, they shouldn't even have a right to appeal because they have no interest in this. There's documentation for everything that they claim. There's amended plans, the original construction documents, and the amendments to those plans, in my opinion, constitutes an approvable set of plans. Yet they still claim that the plans have to be updated completely to include all the changes that have been made. And so I'll apologize up front for wasting your time because I don't think this is appropriate. We're here to appeal the extension of a temporary occupancy, and it should have to stand on its own. And the occupancy permit has been extended. They claim that it's illegal to extend a temporary occupancy or to an extended occupancy at all because the code doesn't allow for it. Yet it's very clear in the code that there is a provision for the extension of a temporary occupancy. This is not entirely the Adams' fault for the delays that have taken place. The city bears responsibility in part of that in the time it takes for us to simply review. Now, in this process, we've allowed the fuses and their team to review plans, which also adds to the time requirement to get those plans approved. And so the extension of a temporary occupancy to me seems absolutely appropriate based on all of the conditions involved. Do you have any questions for me? Because if not,
I do, if you would. What items are remaining in order to receive the full certificate of occupancy?
Final grading and an approved site plan and final grading.
Curious, is the engineer of record for the house that was built, is he here?
No. Again, I didn't feel there was a need since the appeal is for the extension of a temporary, or the complaint against the extension of a temporary occupancy.
So, Corbett, did you perform all the inspections, or
I did
one of your
everything.
agents perform all the inspections?
Yes,
And you found that it was in med code compliance?
yes.
You said Sunrise did some inspections on it.
Well, when he referred to my agent, that's what I'm referring
Yeah.
to. So I did inspections, I did footing, foundation, underground plumbing, and Sunrise did everything else. Along with the engineer of record. So I know the engineer of record was there at the four-way inspection, or there after the four-way inspection. But other than that, yes, Sunrise did all the inspections.
Is that all you'd like to tell the board at this time?
As far as I know, yeah. I mean, they've brought up the lack of reinforcement in the north foundation wall. The engineer of record has demonstrated that it's adequate based on the passive restraint of the fill material on the outside, which hasn't been performed yet because we're lacking a final site plan and grading. We have had third-party review. David Alter was retained by the city to do a third-party review. He has actually been on site, made a site visit. He's gone through all of the documentation, and he has found that there are no life safety issues as claimed by the fuses.
All right,
That's
does
it.
that conclude your?
Yeah.
Okay.
I got a question. The third-party review of the site, was that an engineer hired by the city?
Yes.
Or, okay.
No, it's an engineer.
Not by the property owner.
No, that's David Alter, Ensign Engineering.
Gentlemen? Items for discussion? Yeah, you're good. There's a couple things that, one, I'll ask for some more information from the appellant. But I did hear the approved plans come up quite a bit. And this is one where I agree that we do need to have accurate construction documents to proceed. However, I'm very heavily involved in the legislation process as it pertains to construction code. And there has been continual language that has been passed and proposed by lawmakers in which really ties our hands as it pertains to single-family home construction and the construction documents. Currently, if a plan is stamped by a or a licensed engineer, then we are not allowed to send back for a redraw. We have to accept plans. We can do red lines, but we cannot send it back for redraw. And the state retention code for single-family homes is 1 year after completion. And so I fail to see the importance of having accurate documents if we're only bound to keep those for 1 year. If they have met the code during construction, that's the most important thing. And so I really, I kind of fail. I know the code says that we need to have accurate construction drawings. And that's true, but that's for the construction of it. After the fact, the state will basically say, we don't care. If the inspector passed off on it and a design professional has engineered it, then we don't care. And you only have to keep those plans for 1 year. Now, Woodland Hills may have a different retention schedule. I don't know. But state law only requires that retention for 1 year. Let's see, what other, go ahead.
One statement or question I have is, this Board of Appeals is for the extension of the temporary certificate of occupancy itself, not the grounds of what it was issued on, or whether there's issues with the structure. We're not here to determine that or even weigh in on that. This is for the extension of the temporary C of O. The building code does say that the building official is authorized to issue that temporary C of O and is authorized to dictate the time frame of its existence. So I don't know that, although the information is great, but I don't know that it's pertinent to, I don't know that it pertains to the actual appeals request.
Well, that's what I see too, is that we're dealing with the appeal of the actual decision of issuing a temporary certificate of occupancy. And that really, the issue of safety comes up. And how do you really decide that? What, are we talking about imminent collapse? Are we talking about the potential of a problem in the future?
And that's where my question comes, and we won't count this towards your 10 minutes, but if you could explain to me how the fuges are impacted by the occupancy of the structure.
A couple of points to push back on just a little bit, if I could.
If you could
I will-
address my question,
I will address your question.
and if you're addressing the question, I won't count it towards your 10 minutes.
Yep.
If you're making other points, we'll count it towards your 10 minutes.
Right. So again, your question is how how are we impacted by occupancy of the structure? Okay. I'm impacted because the code is not being followed. It was not followed during construction. The home currently presents, as you've heard here, life safety dangers to our family and to our property. We're currently in a situation where we don't know the stability of that north foundation wall. The city has not ever had accurate plans of what has been built. It's not that they existed for a year and now we don't. They've never had them. We don't know what the top of foundation wall is. And that number by the engineer of record has changed depending upon which submission he gives and how he's trying to back engineer the calculations to make reverse engineer it to work. So we're impacted by the safety issues, the imminent safety issues of this property. The occupants have had this temporary certificate of occupancy. Today is exactly 1 year from the first issuance of that temporary certificate of occupancy. There have been no substantive rectification. They haven't rectified many of these life safety issues in an entire year. You all know that occupancy is the quintessential control to allow you.
Do you want this to count as your 10 minutes?
No, I'm explaining why I'm affected by this. So it's the quintessential control mechanism to ensure safety of not only the occupants, but also neighboring properties. State law indicates that because I'm a property owner adjacent to this place where the lot where land use decisions are being made, I'm an aggrieved party. I'm an adversely affected party just by owning property next to this structure that's been built. And so those are the ways that our family is presently endangered by the actions and the recklessness and the willful and intentional actions of the city to completely disregard code, to not require accurate amended plans. And you notice that there hasn't been any engineering stamped anything submitted by the city to state otherwise.
Any other questions before we let them have their last? Okay. So I think point of order, we'll let the city have 10 minutes and then we'll let the appellant have the last 10 minutes.
Okay. There are accurate plans when you consider the original construction documents and amendments to those plans as one complete set of plans. The engineer of record has stamped the original plans. He has also stamped all of the amendments, all of the calculations associated with the north foundation wall, the grading, the backfill, the retaining walls. The engineer of record has stamped everything. The concern about the safety of the home, I believe, is in the mind of the Fuges alone. They speak in generalities. They won't ever speak in specifics unless it's about the north foundation wall. And in my opinion, that issue has been resolved because the engineer of record has addressed it. Just because the city hasn't responded to their engineers and all of their requests doesn't mean that it hasn't addressed the issues. They don't have a right to the information. We haven't responded directly to them. That's all I have to say.
Any questions for? Fuja?
Yes.
Well, yes, 12 minutes. Thank you for the reminder for that.
Conrad, you've just heard the representations of Mr. Stevens. Do you agree with what he's asserted?
In some things, yes, and other things, no.
What is the no?
The no is that the stability of the north foundation wall in its present condition is a safe condition. He has said that until when the wall is backfilled, then it will be stable. It is presently not backfilled. It is 13 foot tall, covered to frost depth, at least, presently. And until that wall is backfilled on both sides, it is not stable by calculation. Another part, we've talked about grading. You mentioned that they changed they lowered the top of foundation wall, changed it to a wood frame wall. The site plans that were submitted show soil against what is now a framed wall. As we know, we cannot do that unless it has been designed as a permanent wood foundation. That has not been done. He also said that the engineers had not visited the site. I have visited the site. I have not been on the property. I have observed it from the street. So as far as not knowing what has been constructed and not having seen it, that statement is incorrect. There are some issues as well with the site plan and being able to achieve the grading that the engineer record has proposed and achieve the backfill heights to provide stability. Those are more Kyle Spencer's area of expertise, so I will let him address those.
I was hoping I was going to get a chance to get up here because, George, as you mentioned, the plans are good. You're expected to honor the plans if they're stamped by a civil engineer, right? Well, the original first set of plans on the north side of this property that we're talking about, this wall, their site grading plan missed the finished grade by 6 feet on the north side of this house. It set a nice gradual slope. Now we're talking about installing who knows how tall a big wall, or just to allow soil to backfill on this exterior foundation wall. Didn't mention on the south side of this property, the original plan called for a 3-to-1 gradual grass slope. Today there's a 10-foot cast-in-place concrete wall, which requires a 6-foot security fence on the top. These are the errors that we seen on the original review that were basically missed on the original plan, saying this is buildable. And then so that's really where I got looking into it, going, okay, how are we going to build this thing? What else is? If there's a total of 6 feet on the negative, 10 feet on the positive, there's 16 feet difference on this site grading plan. I find it hard to compensate for that. I can see compensating for 6 inches to a foot to make this site work. And that's what we do, right? Backfill, we're going to try to get it close enough for grade. There were some other grade concerns that I've seen too on the site plan. I'm not sure this applies here, but in Woodland Hills, we have that earthen ditch that goes along the roadway that takes care of the roadway drainage and the drainage from the frontage of the property. In this case, also the house with drainage out to the front of the front yard. Where they are tying into that existing drainage channel along the roadway is on the high side of the Food Just property, on the low side of the project that we're looking at. They're totally removing the embankment of this ditch, which in essence would allow the drainage to drain not only from this property, but also the roadway above grade from this site, all funneling on Food Just property. I find that extremely disturbing. Does it have anything to do with structure? Yes and no, because the grade and get that positive grade away from the structure out to the site, into the road, into that drainage. And if it's down, reduced down to accommodate a wood structure or wood window, we got to have positive grade away from the structure, and it's got to go somewhere, that side drainage. And also want to comment too, I've been on the site, on the adjacent property from the street side as well as the Food Just property, trying to just absorb and see what are the real concerns. Like I say, facts are facts. I realize we're trying to, make this site design work, but it's extremely hard when the errors are so far off.
All right, thank you, Kyle. Chapter 1 of the 2015 IRC Code says that only through careful observation of the administrative provisions can the building official reasonably expect to demonstrate that equal protection under the law has been provided. As indicated, Our family represents an adversely affected party, an aggrieved party under whom we can seek redress to the IRC-IBC. So we're appropriately here. Regardless of the decisions of this board, Mr. Stevens has an obligation to fulfill his legal duty. IRC 110.5 says the building official shall in writing suspend or revoke a certificate of occupancy issued under the provisions of this code wherever the certificate is issued in error on the basis of incorrect information supplied or where it is determined that the building or structure or portion thereof is in violation of any ordinance or regulation or any provision of this code. You've had 4 engineers who have testified under stamped signature and under penalty of perjury that the building official has not met this standard. The building official has provided nothing. Presently, Mr. Alter, who he likes to refer to, he has not stamped and signed anything related to this. In fact, he's told Mr. Gilson there are serious issues. You need to go back and address these situations because there were such significant deficiencies. And for the last year, we've gone in this iterative process of Mr. Gilson submitting plans with falsified numbers to try to get the grading to work. All the while, the city anxiously waiting to approve it while we're going to the expense of having to review and say, these numbers don't work, we're not dealing with reality. And this has gone on for a year. Therefore, Mr. Corbett Stevens, irrespective of what is determined by this board, has a duty, because it's a shall, it's very clear, it's mandatory, he has to do this because we know that there are portions that are in violation of this code, to revoke the certificate of occupancy. A public servant is guilty of a Class B misdemeanor if he knowingly refrains from performing a duty imposed upon him by law or clearly inherent in the nature of his office. Utah Annotated Code 76-8201. He is a public servant as determined by 76-601. He's an employee of the city. Utah Annotated Code 63G7102 indicates that willful misconduct means wrongfully failing to act without cause where an actor is aware that the actor's conduct will probably result in injury. It's not only a probably, we have experienced injury, our family. Utah Annotated Code 76-814.14 says every person who knowingly procures or offers any false or forged instrument to be filed or recorded with any public office is guilty of a felony. The document that Mr. Corbett provided here, this building safety, which states that as of the date of issuance, the structure was substantially in compliance with the various ordinances regarding building. Mr. Corbett Stevens was already aware that there were significant violations. Now for Corb, this engineering's hocus pocus, but it's real and it's endangering our home. And so he filed a false document there, and it's out of the purview of your jurisdiction, but he's now being put on notice in the public record. Mr. Stevens, in not verifying the as-built structure with known departures, we don't have to be on site. We can take photographic evidence and notice when a wall on the plans are indicated to be 2 or 3 feet and it's now 9 to 10 feet. And we don't have sufficient evidence of rebar or what the stability of that structure would be. We don't need to be on site to see those. They're so glaringly obvious. But without obtaining accurate plans as to what's actually even been built, to even know how it's been reinforced, he's concealing that important evidence. And per 76-8-510.5, he is tampering with that important evidence in this official proceeding as well as future proceedings. The work shall be installed in accordance with approved construction documents, and any changes made during construction that are not in compliance with the approved construction documents shall be resubmitted for approval as an amended set of construction documents. The Utah State Property Rights Ombudsman has put the city on notice indicating that they have to have accurate plans. And so regardless of what's been discussed at a legislative situation, this board cannot waive any of the requirements of the code. It will be interesting for Mr. Stevens to recognize that the code specifically limits his access to legal aid in these situations. Regarding R104.8, it states the provision does not grant absolute immunity from all tort liability for employees of the jurisdiction in all cases. An employee acting maliciously and is not relieved of his or her personal liability and will most likely not be defended by the jurisdiction. And I'm sure that members of the city will not afford much sympathy to Mr. Stevens in paying for his legal expenses, as he is now facing additional actions that will be taken personally because of his actions of willful misconduct, which have been well documented. He is no longer protected by the Governmental Immunity Act per 63G 7202(3C). that a plaintiff may bring a civil action if the employee has failed to act through willful misconduct. In this situation, we have a unique situation in this matter. Mr. Stevens erroneously approved building plans that had egregious errors. He then worked with the owner builder to collude to hide those errors. Certain city members appears to be complicit in that, and has refused to require correction of those errors. And so our home is in danger because of his willful misconduct. He's been made abundantly aware of what needs to happen. He's been made abundantly aware of what needs to be done. And so I again repeat, regardless of the determination relative to the issuance of the certificate of occupancy, Mr. Corbett Stevens, who is also the building inspector, has specific duties relative to his certification with DOPL to ensure that this structure is not occupied per Title 9 and 10 of the City Code. City Code states that each day that a violation is permitted to exist constitutes a separate offense. Therefore, Mr. Corbett Stevens, you have 24 hours to act.
Mr. Chairman, can I jump in here? I think that this is absurd that Corbett Stevens, I'm the mayor of Woodland Hills, and I don't want these proceedings to go off the rails, but I think that the fact that Mr. Fuge is attacking his character is, it's clouding the issue of what is really going on here. And I think that for this board to allow him to attack Mr. Stevens without allowing others to stand in defense of Mr. Stevens is out of line. So I think that any implications regarding Corbett's willful misconduct or felonious actions is out of line in these proceedings.
I appreciate the comment. I was letting Mr. Fugia speak his piece. A comment that I was going to make is if that is the case for building officials, you're probably going to see 3 resignations right here in the next couple of weeks. I don't know if my counterparts feel the same way, but if that's the case, then we definitely don't get paid enough to be.
I personally am responsible for it.
For sure. We are in a position where we're caught between all parties. And no matter what decision we make, it's never going to be the right one in somebody's eyes. So I do agree with the comments made that
I will also point out that the instances are not personal attacks. They're evidence that have been provided of the willful misconduct with knowledge as defined by state law. So these aren't personal attacks in any way, shape, or form. We've invited the city, in fact, begged the city to please do the right thing in this matter, and they have intentionally refused to do that.
These are veiled threats. That's all this is.
all right, let's keep it under wraps here. Hold on, it's not a public hearing.
We still have time.
No, I'm one of the appellants. I just wanted to add, I know Mr. Stevens has out a signed stamped thing from Mr. Alter, but I would like to add for your information that he has said that will require correction before it is an official document for the city. He has let our engineers know that he needs to correct that document, that there are problems in that document that he is going to refer to as a document. And we have emails that show that.
Okay. The appeal is about
Has everybody had their time?
everybody's had their time. So the appeal is about extending the temporary certificate of occupancy. However, I'm just going to speak my mind for a minute. The expert witnesses that were brought forward did not give us any explanation of to why the Fujas were in danger. If anybody's in danger, it's the people that occupy the home. But it did pass inspection. There is a licensed professional engineer on the job. I don't see how this appeal really shows that the Fujas are in danger. And I'm offended that somehow the Board of Appeals has been weaponized. It's to protect people from building officials' determinations if they're being unreasonable. And I feel like it's been somewhat weaponized in this process. And I like I said, I deal a lot with state legislature. And Woodland Hills gets brought up a lot in that Woodland Hills is very difficult to build in, and that the rules are just astronomical and they're difficult. And given this situation, I can see why Woodland Hills puts in so many rules. It's, I won't get too far into there, but I feel like if we as a board made a decision to let an adjacent property owner dictate the occupancy of a home that the building official has deemed occupiable, wow, that would explode up the Capitol. And it goes against what the true intent of the Board of Appeals is. But that's my soapbox.
So in the appeal, it says that what it comes down to is, can Corbett issue a temporary certificate of occupancy? And in my mind, the code says he can. And then the next thing it says is that he's determines a period of time. Now, that doesn't say how long of a period of time. It just says a period of time, and it doesn't say you can't change the period of time. I mean, I think the point of a temporary certificate of occupancy is that you've still got issues. They need to be addressed. Sometimes it takes time to get those things done. I'm not smart enough to know all the ins and outs of what's going on this job. I haven't had the time to know that, but if there really is a problem, then the people that have the problem need to be given an opportunity to fix it. And so, that's a discussion for another day, but I think, I'd make a motion right now that Corbett's within that the appeal is rejected based on the fact that there is a provision for a temporary C of O and it's been followed. That's a motion.
We have a second.
That motion.
Do we have any discussion on the motion? Okay, seeing there's no discussion, all in favor, I vote aye. John?
Aye.
Aye.
John? Okay. The appeal has been denied, and the board feels that Corbett Stevens can issue an extension on the temporary certificate of occupancy. Motion to adjourn?
Make a motion to adjourn.
Second.
All in favor?
Aye.
Meeting adjourned.